Hello, everyone. Welcome to another one-on-one Talking Feds. There's been a really interesting development in the immunity appeal currently pending in the DC Circuit and scheduled for oral argument on January 9th. And that is the submission of a so-called amicus brief. We'll talk about what that means by a group that is not heretofore been heard of in the case, but gave a very compelling explanation that the court should hear from them because they have a whole different point of view that no one else has covered, and indeed they do. And it strikes me as, at a minimum, way interesting and possibly a whole different way to decide the case. And newsflash before we go to our guest, the Court of Appeals has now ordered the parties, that being Jack Smith and Donald Trump, to be ready to address it at the oral argument. So I'm joined by Stanton Jones, who is a partner at Arnold and Porter, that august firm, along with Kay Scholler. Actually, they're the counsel of record. I think Stanton is the counsel of record, and so he's the guy who knows the most about it, and we can, talk about the different aspects of it. Stanton, thanks so much for being here.
Thanks, Harry. It's my pleasure to be on. Friendly correction, Arnold and Porter Kay Scholler is now one firm, having merged a few years ago.
Really?
Indeed.
God, this just in, but I guess it's not just in. I didn't realize. I have, well, that's a separate conversation. Okay, guys, so the behemoth Arnold and Porter firm is now the mega behemoth Kay Scholler Arnold and Porter. All right, and Stanton Jones is still the lead counsel here. Let's start here. Everyone has a lot of respect for the man who's come in to handle the appellate stuff for Jack Smith, Michael Dreeben, who's probably the criminal law practitioner of his generation at the SG's office. And so my first thought when I read your brief was, did Dreeben possibly miss this, or where did it come? It came from outer space somewhere. How did it land at your lap, or was it you, in fact, who conceived of it? And do we think that the parties literally have never thought about it? That's a kind of a teaser question because we'll go after that to what the it is. But let's just talk about the genesis of the brief a bit.
Yeah, so I woke up on Christmas Eve morning just a couple of weeks ago and thought to myself, why does the DC Circuit get to hear Trump's immunity appeal on an interlocutory basis, right? As one does on Christmas Eve morning when you wake up.
Exactly.
These are the thoughts that you have.
Right.
So I
Well, putting out the milk and cookies for Santa. Yeah, okay.
Exactly. So I turned on my computer, spent a few hours doing some research, and as you read in the amicus brief, there's actually quite a bit of law. You might say that the law is on point, that in fact Trump can't appeal on an interlocutory basis because his issue is subject to the ordinary rule that you need to wait until there's a final judgment, which means in a criminal case, a conviction and a sentence.
So literally, you just woke up and had a kind of a nagging feeling and hit Westlaw and came up with this idea.
Yeah, I mean, I'm in the appellate practice at Arnold
Right.
and Porter, and frankly, one of the most common questions that we get as appellate lawyers is from clients or colleagues asking, I just lost something. Can I appeal right away? And
Yeah.
oftentimes the answer is no.
And by the way, just to the stakes here of appealing right away versus not are humongous. Could you kind of lay them out a bit?
Yeah, sure. I mean, Judge Chutkan in the district court has ruled that all of the pretrial proceedings and trial are put on hold pending the appellate proceedings. So as long as this thing is in the DC Circuit or the Supreme Court, the trial won't move forward. Now, the trial was scheduled for March, a full-blown DC Circuit appeal followed by Supreme Court merits review, where the justices to grant certiorari would typically take many months, and most notably here would typically take push the appellate proceedings past the November election. So really what's at stake here, I think, is whether Mr. Trump will be tried for these offenses before the November election.
Right, which is huge. As you say, all of Trump's stuff has sort of goes on two tracks of analysis. One is what's up with the merits, but the other is how much delay can he wring out of it. And of course, the Chutkan trial, both because of the seriousness of the charges and and their sense of capturing what was most wicked about his presidency, but also because Judge Chutkan herself seemed, poised to move, as did Jack Smith. I mean, it's noteworthy that Trump is the only defendant here, even though there are six unindicted co-conspirators. So it was really the chief focus for a meaningful trial in advance of the election, and so this was his big shot at delays, because as you say, I'll just lay it out a little. When he's claiming he has immunity is generally thought of as an entitlement not to stand trial or even to be exposed to the rigors of pretrial litigation. And so Chutkan held, after ruling against him on the immunity motion, that he could now take it up to the Court of Appeal. Well, we first had that funny little shuffle involving asking the Supreme Court to take it immediately. Then it turned out that the DC Circuit was moving very quickly. But anyway, the issue is, does he get to have this stay? We've been assuming that he does get to have it. Therefore, everyone's been wondering how quickly can the merits be decided, because until then, we're basically in a day for day dynamic where each day that it's not decided it pushes back one day the feasible starting date. Okay, so want to lay out the Christmas Day brainstorm. Well, actually, I want to ask you a little bit more, because it's the appellate lawyer's art. What was it, Stanton, that kind of got your antenna buzzing about this being wrong? It had been an assumption of a lot of people that he's going for immunity. Remember what happened in other cases like Harlow versus Fitzgerald, civil cases, and I don't think people did second guess it. What was happening in your gut that told you I should look into this more?
Well, I knew that denials of immunity are immediately appealable in civil cases. I've handled those cases before on appeal. A defendant in a civil case who loses an immunity motion in the district court can take the issue immediately to the Court of Appeals, and that appeal has the result of staying all of the pretrial proceedings in the district court. But it just occurred to me that that might be different in the criminal context. Delay is always disfavored, including in civil cases, but certainly in a criminal prosecution,
Yeah.
it just seemed to me at least plausible that there might be a different rule, a stricter rule, limiting the circumstances in which a criminal defendant would be able to pause their prosecution and take an issue to the Court of Appeals in the middle of the case before trial.
Got it. Well, hats off to you, because I can report that we have a sort of informal conversations among some of the, usual suspect pundits, and a couple of them, including Andrew Weissman, Norm Eisen, also had similar, does this really fly kinds of feelings. But so when your brief arrived, and by the way, so you go from the 25th to the 30th. That's so you put it together in very short order. Kudos on that. Then you find and really lay out the argument. So please have at it. Explain to us, and our listeners have become more and more legally sophisticated, but most of them aren't lawyers. So lay it out as straightforwardly as you can. The basic insight and argument in your brief.
Sure. So the typical rule is that you can't appeal until there's a final judgment. It's called the final judgment rule, and all lawyers learn it during their 1L civil procedure class. The
Right.
final judgment rule You cannot appeal until there's a final judgment. After there's a final judgment, you can take up any of the issues that you lost typically during the case, but you have to wait for that final judgment. Now, there is an exception to that final judgment rule, which is called the collateral order doctrine. And the Supreme Court has held since a case called Cohen in the 1950s, I believe, that there are some orders in the middle of a case before a trial that are where the issue is collateral, separate from the merits of the case, but for which it would not really be reviewable if you had to wait till the end of the case. And so in various contexts, the court has allowed immediate appeals in the middle of a case, pre-trial of these collateral orders. And it turns out there is a Supreme Court case, a 1989 decision.
Well, let's set the table a little bit more. Okay, so they have allowed it in some instances, and the consequence is you put the trial on ice. But as you said, it's exceptional. Now, the 1989 case is the Stanton Jones epiphany. But let's start with where the parties were and why both sides just simply informed. In every case, you've got to explain why the court has jurisdiction. That's just rules of the game. That is why it has the power to hear the case. And when it's interlocutory like this, you have to explain that. And both parties just said the same thing. You can do it. So explain what everyone thought was the default rule, and then before we come to this 1989 case.
Yeah, so in every appellate brief, the parties are required to include a jurisdictional statement, just explaining why and how the Court of Appeals has jurisdiction. And in this appeal, both sides, Mr. Trump's lawyers and the special counsel, said in their jurisdictional statements that the D.C. Circuit has jurisdiction, citing cases that we don't think apply, but citing
but still. I mean, there's some very big presidential cases. I mean, they right. There's what's the main case that they think made it just straightforward?
Yeah, the main case would be Nixon v. Fitzgerald, which is a case involving former President Richard Nixon. It was a civil lawsuit against former President Nixon seeking money damages, and the court held in that context that the trial court's order denying Nixon's motion to dismiss the civil lawsuit, money damages lawsuit against him on presidential immunity grounds was immediately appealable. Again,
right, so let's just stop right there. That if that's all you knew, it sounds like it casts a very big shadow if it's not identical. It's true that you were thinking, would it be different in the criminal context? But then comes along. Well, let me go back for 1 second. What's your best guess that this 1989 case that you're about to describe didn't occur to the parties, or it did and they didn't think it was worth mentioning?
I'm tempted to say that it was an American oversight, but that would be
right.
The world's worst pun. Apologies.
Yeah, not at all. Yeah. Okay. So
no,
anyway,
I actually don't. I don't think that it was an oversight.
It's so hard to think that Dreeben wouldn't have seen this, right?
I mean, I have just enormous respect for the special counsel's legal team. He has some of the best lawyers in the country, in the world. I think that they believe what they wrote in their brief, which is that they believe that there is jurisdiction here.
Yeah. Okay. So that's kind of a head scratcher. We'll know more about it in a week when they have to confront it. All right. But that's what it said. It's an immunity case, civil immunity, but there's a sort of, under the Cohen doctrine, as you say, kind of a 3-part test, and they just said, citing the Fitzgerald case, that it applies, etc. And then I don't know if we're in Boxing Day now or still on Christmas, you find this 1989 case called Midland Asphalt. Tell us about that, please.
So Midland Asphalt was a unanimous decision from the Supreme Court written by the late Justice Scalia. And what the court said there, it was an attempt by a criminal defendant to appeal a pretrial ruling denying the defendant's motion to dismiss the indictment against him on the basis of a violation of the rules requiring secrecy in grand jury proceedings. And the Supreme Court, in this unanimous opinion written by Justice Scalia, said a few things that are relevant. First, said that this collateral order doctrine, this exception to the usual final judgment rule that pushes all appeals until after conviction and sentence when there's a final judgment, the court said that the collateral order doctrine is applied with the utmost strictness in criminal cases. And that goes back to principles that say the policy against piecemeal appeals and the policy against delay are at their apex, at their height in the criminal context, because the Supreme Court has long said that delay can be fatal to the vindication of the criminal laws. Evidence can become stale, and even if the evidence is preserved, delay in a criminal case frustrates the community's interest in bringing criminal offenders to justice. And so the court in Midland Asphalt says that the collateral order doctrine, this exception to the final.
And by the way, even though it's a company, it was a criminal case. The company was a criminal defendant, right?
Correct, exactly.
Yeah.
So the court says that this exception to the final judgment rule, which allows you to take an appeal before trial, is applied with the utmost strictness in criminal cases, different from civil. And the other critically important thing that the court said was that an order denying a criminal defendant's argument to be free from trial is immediately appealable only if the claimed right to avoid trial rests upon an explicit statutory or constitutional guarantee that a trial will not occur. So you have this requirement that that the criminal defendant seeking to appeal an immunity or other right not to be tried must point to explicit text in a statute or in the Constitution that says, I have a right not to be tried.
And there seem to be only 2 or 3 or 4 really clear instances of that. Give us a very good example of something that would satisfy the even restrictive view that Midland Asphalt requires.
So in Midland Asphalt, the court actually identified 2 provisions of the Constitution that do provide an explicit guarantee against trial, and that was the double jeopardy clause, which says if you've already been tried once, you can't be tried again.
You may not be be put in jeopardy twice. So yeah, exactly. Okay,
And
it's
the
the
other
trial
is
itself that's the offense. Okay.
the other sufficiently explicit provision of the Constitution was the speech or debate clause, which provides special protection for members of Congress.
And similarly says that they shall not be held, et cetera. Okay. And what about a statute? Anything come to mind there?
Sure. So there are statutes that provide immunities. The Foreign Sovereign Immunities Act is one example where interlocutory pretrial appeals have been allowed in criminal cases brought against foreign governments or agents of foreign governments, because the Foreign Sovereign Immunities Act, as the name suggests, is a federal statute that explicitly confers immunity on foreign sovereigns and their
That's
agents.
very right. Okay, and importantly, the test, the so-called 3-part test, was word for word the same as the Cohen test you explained from many moons ago. So it's really a gloss on it. It doesn't purport to be changing the law. Okay, so but it takes the third part of the test and imposes this requirement of it's got to be a constitutional or statutory provision that by its terms gives a right not to go to trial. And Scalia makes an important distinction between a claim that if you're right, the trial goes away versus this very kind of thing. All right, so let's try to apply this what seems to be the new critical test after 1989 to a claim of executive immunity. How would you analyze the requirement of express freedom from trial in the constitutional statutory provision from immunity, because it still remains the case, right, colloquially, that immunity is about being free from the rigors of litigation and trial. Yes.
Yeah, sure. So fortunately, we have a lot of help in figuring out how to apply the Midland
Yep.
Asphalt test from decisions of the courts of appeals. There are dozens, maybe hundreds of decisions from the Circuit Court of Appeals since 1989 dismissing interlocutory appeals in criminal cases under Midland Asphalt. And the straightforward test that they apply is simply, does the criminal defendant who's seeking to take this early appeal point to a provision of a statute or a provision of the Constitution that explicitly confers on the defendant a right not to be tried? And if the answer is yes, the defendant does point to such a provision of a statute or the Constitution that provides that explicit textual guarantee against trial, then the appeal is allowed. And if not, the appeal is dismissed for lack of appellate jurisdiction and sent right back to the trial court. And so applying, and the DC Circuit, where Mr. Trump's appeal, of course, is pending, has a number of decisions in the last 30 years dismissing appeals, finding that the Midland Asphalt test of an explicit textual guarantee against trial was not satisfied, including one decision by one of the DC Circuit judges who happens to be on the panel in Mr. Trump's case.
Yeah.
And so applying that Midland Asphalt test here, looking for, does Mr. Trump point to a provision of, all of his arguments are constitutional. So does he point to a provision of the Constitution that explicitly confers on him a right not to be tried? And when you look at his arguments on their face, he doesn't. He makes two arguments. One is that he's entitled to presidential immunity. And Judge Chutkan in the district court put it very well when she wrote, there is no presidential immunity clause in the Constitution. And indeed, Mr. Trump doesn't argue otherwise. He does not point to, even try to point to any specific text in the Constitution that supposedly establishes this immunity. Instead, he says that there are 7 different considerations that the court should look to, including things like history and tradition. He points to the structural separation of powers, but multiple courts, including the DC Circuit, have held that structural separation of powers arguments do not explicitly confer a right not to be tried for purposes of Midland Asphalt, so that's not good enough. So his presidential immunity claim is simply not based on explicit text in the Constitution, and therefore fails Midland Asphalt, just as occurred in a number of other cases.
All right, but this let's follow up here, because it might be a little different, and let's try to do see it from the other guy's potential point of view. So it's pretty straightforward. If there's something like in Midland Asphalt, a claim that gives you some kind of right, that the remedy for which is dismissal, but that's not, it doesn't state it in those terms. I see the difference there. But presumably, and by the way, hats off to you, the court has said already to the parties, you better be ready to address this next week. There's some kind of more loosey-goosey argument that, yes, it's not a specific provision, but it is a constitution we are expounding. And the allowance for presidential immunity is textually based, in the sense that I've got to apologize for my rambunctious 2 doggies. That you sort of cobble together policies, provisions, and the like. So it's once you've done that cobbling, you produce an entitlement not to go to trial in a way that's sort of integral to the right. It would be something like that, yes. So that it would involve a little bit of play in the joints on the actual, textual constitutional provision. Yes, is what I've said. Do you think the way you anticipate Trump responding? And do you think it's something you could make very quick work of? What's their best way of putting it?
Yeah, I do. I expect that they would make some kind of argument like that, including because the criminal defendants in many of the prior cases involving the Midland Asphalt rule have made exactly that argument.
Oh,
Many,
really? So because I thought immunity is sort of special in this sense. I mean, they're normally going under some specific remedy that gives for dismissal, but there aren't. I know there's one case in the First Circuit involving judicial immunity, but it doesn't in the way I've just described, doesn't that seem kind of a different footing for executive immunity claim than say another entitlement?
no, actually, the DC Circuit in a case called Cisneros
Hmm.
dismissed an appeal, an interlocutory appeal, pretrial appeal taken by a former cabinet secretary.
That would
Uh,
be Henry
who
Cisneros. Okay.
he claimed that he was immune from prosecution under the structural separation of powers. So really the same type of argument that Mr. Trump is making. And the
I
DC
didn't.
Circuit in that case held that that type of structural separation of powers argument, although it is grounded in the Constitution, of
Yeah.
course, structural
Uh-huh.
separation of powers arises from the Constitution. It doesn't meet the Midland Asphalt test for an interlocutory appeal because there's no explicit text in the Constitution that says if a prosecution violates the structural separation of powers, you have a right not to be tried.
Wow. So that's really impressive. And going back to immunity itself, and Nixon versus United States, its genesis seems famously to be soft, constitutional policy driven and sort of inferred, derived, etc., but something very different from the firm guarantee. All
Yeah.
right, well, so I mean, man, this is seeming pretty strong. And again, I'm scratching my head why it wasn't thought of before. So let's do the so-called pre-mortem. Let's assume you lose. How will the court be writing it, or the Supreme Court write to get around this apparently compelling argument? What do you see as the sort of, biggest risk?
Well, one issue that's been raised is that Mr. Trump does invoke a sort of double jeopardy argument. Uh,
Okay, so uh, let's go to that in a second. I see that, and double jeopardy is such a clause. But let's stick with immunity for now. I mean, you're an appellate lawyer, you see things in a clear-eyed way and always tell the client, oh, it's about 70-30 or whatever, as one has to. What do you see as the way the Court of Appeals or the Supreme Court hold against you on the immunity argument?
I mean, under the existing law, I think it's exceedingly clear that there is no jurisdiction here. Really, I think probably the most likely way that at least the Supreme Court could reach a different conclusion is just to say that presidential immunity is different.
Yeah.
The Supreme Court could do that, of course, because it's the Supreme Court. I don't
Yeah.
think the DC Circuit could do that and say, we sort of predict that the Supreme Court would carve out some kind of exception. It seems especially wrong when the whole case is about the fact that no one, even the president, is above the law. Well,
Right.
no one is above the law of appellate jurisdiction. And here, the law of appellate jurisdiction is just really clear that you can't appeal yet. It's too early.
Okay, so you really see that, you think it's almost bulletproof for the Court of Appeals. I won't hold you to it, but I mean, I hear you. Okay, let's move for a second to the double jeopardy. He launches two arguments. The double jeopardy clause does, by its terms, provide a right not to be tried, but it's an extraordinarily weak or funky double jeopardy argument. How might that play out in terms of the Midland Asphalt analysis?
So the Supreme Court said in Midland Asphalt that the arguments under the double jeopardy clause are the type of order that satisfies this collateral order doctrine. So you can take an immediate appeal. The rub here is that Mr. Trump is not arguing the double jeopardy clause. He actually, in his appeal brief, he criticizes the district court for having analyzed his
Yeah.
argument under the double jeopardy clause. He says, I'm not invoking the double jeopardy clause. What I'm saying is something different. What I'm saying is that a different clause in the Constitution called the impeachment judgment clause, by negative inference,
Right.
creates a double jeopardy-like principle, which is that if a president is tried and acquitted by the Senate, then they can't be criminally prosecuted. But that is not the impeachment judgment clause does not say that. And even by Mr. Trump's own argument, he's simply claiming that a negative inference
Right.
from the impeachment judgment clause gives rise to this double jeopardy related idea. And I mean, just to say it, a negative inference is negative. It's not based on the text. It's not based on what the provision says. It's even in Mr. Trump's own view of it, his argument is based on what the clause doesn't say. And that doesn't satisfy Midland Asphalt.
Yeah, that's very good. Let's switch over and get sanguine about it. For you are you gonna ask the court for time on Tuesday?
No, we're not
Yeah.
intending
Okay.
to ask for it. It's a criminal case, and
Yeah,
certainly
you wouldn't be likely to, but it may be that you have to look to the judges rather than the parties. It's funny because this would seem to be in the interest of the United States, but it may well be the devil's advocate role is played by one on the panel. Let's just play it out timing wise. So if we're thinking in sheer practical terms, legal merits aside, the great insight here, or the great benefit of your argument is that the delay would stop, and in short order, no jurisdiction. That means it's back with, and always should have been with, Judge Chutkan, and the schedule resumes. But the question is the sort of timing for that to happen. And you can imagine a court, maybe the Supreme Court of the United States, thinking better that immunity be decided before trial, just for the sort of American people, or what a disaster it would be if we were actually to reverse it post trial on immunity grounds, etc. I bring that up only as a way to give context to suppositions about scheduling. So let's say that on the 9th, the parties address this, and the court in conference after is persuaded of the Midland Asphalt point. Now, you would think, because it's so sort of blunt and direct, it would move very quickly back to Chutkan, or would it? Is there any, now that we're here, and now that the Supreme Court might have to decide, and it would have the liberty, or the ability to change the rule, how would you see it playing out in schedule, and is it a net advantage to the American people in terms of being back in Chutkan's courtroom sooner?
Yeah, I mean, what I'd like to see is for the DC Circuit to dismiss the appeal for lack of appellate jurisdiction under this very settled, simple law that there's no explicit text in the Constitution conferring this supposed immunity. So Mr. Trump, like every other criminal defendant in America, needs to wait until after he is tried and convicted and sentenced for the offenses to take an appeal.
Well, let me stop you right there, because I'm trying now to zero in on timeline. So they do that. Do you see that as being, because it looks like they're moving with great dispatch already? Do you see that as being quicker than a decision on the merits that he lacks immunity?
I'll put it this way: from having the question in my head about this issue to filing the brief took 6 days.
Yeah.
And so, from doing the basic legal research to putting together a team of terrific Arnold and Porter colleagues
Yeah.
to getting in contact with the amazing folks at American Oversight, it all took 6 days. So this issue, the Midland Asphalt issue, is actually strikingly simple.
Yeah.
You
Okay.
just ask yourself, where is the explicit text of the Constitution that confers this immunity on you, sir? And it's just not there. So
Okay.
I think
So
it
what
should
do
be
you,
fast.
let's say that's right, and let's say it's roughly maybe a little bit sooner than it otherwise would be. Now let's think about Supreme Court review. Hopefully, this is a whole separate question, no matter how they go. But hopefully, the Court of Appeals puts a short stay on things, so he's got to move to the Supreme Court quickly. All right, but now, if they've so held, how do you think it works, again, with particular attention to timing, in the Supreme Court, which, as you say, would have the ability? So one of the questions presented, I guess, would be, should Midland Asphalt was it properly interpreted, or should it be modified to permit presidential immunity, et cetera, et cetera? How do you see the court handling that, and do you see a net time savings in when a jury is impaneled in U.S. versus Trump in Judge Chutkan's court?
I do see a very significant possibility that this would save a lot of time because if the DC Circuit dismisses the appeal for lack of jurisdiction, in
Mhm.
my view, that issue is not cert worthy. It's
Yeah,
there's no circuit split. There's no conflict among
right.
lower courts. It's based on a very straightforward application of a unanimous Supreme Court decision from 35 years ago that the
Yeah,
courts of appeals have routinely applied to dismiss interlocutory appeals in criminal cases, including lots of interlocutory appeals where the criminal defendants were trying to invoke various forms of immunity. Those
yeah.
appeals are just routinely dismissed for lack of jurisdiction. I don't.
Which, by the way, I don't think would give heartburn here to the Supreme Court if they, given that, Colorado is coming at them like a freight train, to not have to sort of weigh in pivotally. They may like, or and there's also the possibility of a summary affirmance. So let's say that's right. Either they deny cert or they summarily affirm. Any sense, Stanton, about just the timing of that? Can they? Would you expect the DOJ, even though they're the winning party, to ask them to decide it quickly, or what we have, let's say, as early as Martin Luther King Day, a decision by the Court of Appeals saying no jurisdiction. When how do you see it playing out timing wise so that it's back in Chutkan's court, and give and factoring in to the analysis, as we always must, one party who's looking to delay as much as he possibly can.
I think it could happen extremely quickly. As you indicated, the DC Circuit could essentially put Mr. Trump on a clock to
Yep.
seek Supreme Court review by ordering that it will issue the mandate, which returns the case to the district court
Yeah.
within so many days after its decision, unless Mr. Trump files a petition for certiorari with the Supreme Court in that time.
Right.
So they essentially put him on a clock. Call it 14 days.
Okay.
And then the special counsel can move things quickly as well by quickly filing a brief in opposition to
And
Mr.
move for
Trump's
expedited treatment. Yeah. And then it's served up. And by the way, oh, I see. You think the Court of Appeals would say, as long as you file a petition for cert, the will stay the mandate, because you could say you got to get 5 in the Supreme Court. This is straightforward. We're not going to stay the mandate. But
Sure, that would be even faster.
yeah,
But if they wanted, out of some measure of deference for a former president to give him, some reasonably short opportunity to go to the next court up the chain, they could do that, or they could just issue the mandate right away. As I say, I mean, this is the courts of appeals dismiss these interlocutory appeals by criminal defendants all the time.
yeah. Well, this Cisneros case is something that at least pointy-headed guys like me ought to be reading, and I will, because I know much of the background, but not this. So, okay, so this happens now pretty quick. I again just trying to figure out where the parties are, because they're the ones who are going to have to carry your water. You needed to reach out to them to get consent to file, did you not?
We did.
And did as part of that, if you're permitted to say, did you explain the issue?
We did say in our email requesting consent for the filing of the amicus brief that we would be arguing that the DC Circuit lacks jurisdiction. Yes,
You did not say that.
we did. We did. We
You
said that in
did
the
say
email.
that. And did you say Midland Asphalt?
We did not cite any cases in our email.
That's all you said. Okay. And did both parties assent?
No, the United States did not object to the filing of the amicus brief. Mr. Trump's lawyers did not reply to our email.
Gotcha. And then it was just this morning, am I right, that I know the courts instructed everyone to respond, and they say amici. There are only two, as far as I know, right? The amicus brief. So that must mean you guys, correct?
I believe that the court's order directing the parties to come ready to talk about the amicus briefs is a nod to the American Oversight amicus brief on jurisdiction. Yes.
Yeah, and there's one other, but at least as I read it, by a bunch of very eminent conservative former law enforcement types, but it's not really novel or different arguments like American Oversight. Well, okay, this could be like the appellant equivalent of a Perry Mason show that hardly ever happens in real life, where somebody strolls in with a whole new idea and it carries the day. I'll certainly be watching really, really closely, and congratulations to you just for coming up with it in that intense 6-day period. Does it have have you talked to your colleagues about it? I've spoken to people about it who suggest they won't do that, will they? And then you ask for, this isn't just the law, it's jurisdiction. It's pretty funky to be monkeying around with a jurisdictional doctrine about power of the court in the first place. If it's not otherwise there. So, I don't think even if there are the courts would think there's a benefit to deciding it on the merits, they got to write the thing now, and so as you say, I don't see what a court of appeals done. Now you're much more familiar with it, but even it's only been a couple weeks. This is going to be counterintuitive to a lot of people. So let me just say it's a great sort of little legal drama. Will this prevail? And if not, why not? And that second question, I at least don't have a good answer for right now. Any sort of final thoughts, Stanton?
A lot of people that I've talked to about this have an instinct or a gut
Right.
that the DC Circuit and the Supreme Court will want to decide the underlying immunity issues
Right.
and will try to figure out some way to get there.
Yeah.
I don't know whether that's true or not. But I have another instinct, which is that in a case of this magnitude, it's super important for the courts just to apply the law as it stands. And in the DC Circuit right now, the law as it stands is that there's no appellate jurisdiction over Mr. Trump's interlocutory appeal of his immunity arguments because they don't rest on any explicit text in the Constitution, even as he frames the arguments. And so I think that the best thing to do would be to just apply the law as it is. Midland Asphalt and the Court of Appeals decisions applying Midland Asphalt to dismiss appeals, and the chips will fall where they may. But speculation or predictions about what would the court like to do, to me are really not responsive to the point that this is the law of appellate jurisdiction is part of the law. It's part of the rule of law. You have to wait.
Indeed, every party must speak to it in every single appeal. It's not kind of an afterthought, right?
And courts take it extremely seriously, and courts have an unflagging obligation to raise potential defects in their jurisdiction, even when the parties don't raise it, which is the case here.
Yeah. Okie doke, Stanton Jones. We'll be following closely, see how many minutes into oral argument till the first judge brings this up, and then what the parties have to say. Thanks so much for being with us today, and maybe we'll talk to you on the other side of the DC Circuit holding.
Thanks, Harry. It's been a pleasure.
Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.